Josh Denbo, consumer protection attorney. I sue banks, I sue rotten car dealerships and other creeps, and I absolutely love my job. Today is a deep dive, wonky legal nerd out. So if you're interested in that kind of thing and how the sausage is made, and we're talking about the Truth in Lending Act and a very big deal that was just announced by the FTC, this is the video for you. If you're not into this kind of thing, watch my other videos so I go on to other more basic stuff. But I want to talk about the Truth in Lending Act. The Truth in Lending Act is the statute that governs how people are told the cost of their credit when they go to finance something. There's no easier way to explain it. And the idea behind the Truth in Lending Act is if you go finance a lawnmower in Anchorage, Alaska and in Miami, Florida, you should be able to compare the two documents and know whether you're getting a better deal in one place or the other. It doesn't exactly work that way, but that's the goal of the Truth in Lending Act. And the enforcement of the Truth in Lending Act is a little bit tricky. Now, it used to be that only the Fed had the right to enforce the Truth in Lending Act, and they never did because their mandate is not individual consumers. And then it was changed so that the individual consumer had a private right of action. They could sue under the Truth in Lending Act. Look, Mr. Car Dealership, you sold me a car, but you lied to me about how much the cost of the credit was actually going to be. Therefore, I want to sue you. Easy, right? Makes sense? Two problems. Number one, the statute of limitations on an affirmative claim, on suing for being defrauded by the Truth in Lending Act, is 1 year. And nobody actually knows that they were defrauded within the year. Well, not nobody, but I don't think I've ever come across a client who realized they were defrauded because the fraud is so subtle that it's only discovered when someone comes to me when they're being sued on the debt. I look at the original closing document, like, wait a second, you were defrauded. There's a 1-year statute. However, that means that I can't sue for the fraud, but I can bring what is called an offset claim. And an offset claim is an affirmative defense. If car dealership A sues my client comes to me and says, Josh, I don't know, I can't do this. This is crazy. I turned in the car, they're still suing me for the difference. Let's see what defenses we've got. Boom, I find a Truth in Lending Act violation. That means if they sue my client, I can bring a counterclaim affirmative defense for an offset, saying, okay, you're suing my client for $10,000, but you defrauded her, and my client's remedy is $6,000, so the best you can do is $4,000. And that's before you pay my attorney's fees. With me so far? Good. Here's the thing. The issuance of attorney's fees is awarded under the Truth in Lending Act for people who win their case. There's been a split in various districts and jurisdictions as to whether or not winning a recoupment claim is winning the case. And you can see where this is going. So because there's a question, or was a question, as to whether an attorney representing a consumer and not taking any money up front to do it could afford to could defend the case because they weren't sure they were going to get paid, was a real issue, and it was a real limiting factor on controlling mostly the predatory car sales industry. This is really what it mostly affects. And on the 18th of this month, the FTC issued an advisory opinion on the holder rule on attorney's fees and costs. And what it says is attorney's fees are going to be paid on a recovery, on an offset claim. Now, there's one other legal wonky thing that this FTC rule addresses, because it really drills deep down to the problem and solves it. And that is, what happens when a dirty seller sells the vehicle under financing and then sells the financing to a financing company who owns the debt, collects the money, does what they're going to do, retakes the car when the payments aren't made or there's a collision or something, and then sues on the deficiency. Is that entity responsible for the fraud committed by the originator? All right? You guys can see how complex and complicated this gets. Now, people say to me, well, of course they are. They bought the debt. But on a public policy level, we don't really want anybody who is being sued to be able to sue the owner of the debt. And when my clients push me back on this, I say, okay, let's imagine the United States government wants to build a nuclear submarine and they have 10,000 different vendors and sub-vendors. And there's issuance and lines of credit and notes issued all over the place. Should a should a vendor who didn't pay be able to sue the United States government or whoever and stop the building of the nuclear submarine because someone in the chain screwed around and defrauded them at the closing? The answer is no. We want to have notes, debts being able to be sold without much limitation. But that creates a problem that wasn't foreseen by the geniuses who created this concept of immunity under the S&E. And that hole is, well, all right, from the perspective of a dirty business, I'm going to finance the sale of a vehicle. And then I'm going to sell the note to my brother. My brother's going to collect, but it's really going to be me. But it's a new company, so he's immune. So I can do whatever I want, and I can't get sued for violation of the Truth in Lending Act or anything else because he's immune, and I'm just going to go out of business and form another business someplace. And car dealerships come in and out of business all the time for this reason. So the FTC tried to solve this problem with what is called the Holder Rule. And the Holder Rule applies in every state but New Jersey, and I'll talk about New Jersey in another video, not this one. But it applies in every state but New Jersey. And in that Holder Rule, the owner of the debt is liable just the same amount as the originator of the debt. Okay, so it gets rid of this immunity. So you're saying to me, okay, Josh, well then, what about the nuclear submarine example? Doesn't that just eliminate all the public policy concerns you raised? No, it doesn't, because the Holder Rule also provides that the recovery by the debtor, by the borrower, against the assignee, the person or the entity that owns the debt at the time of this litigation, is limited to the amount that the borrower paid against the debt. You follow? So a borrower who finances a car and gets ripped off and pays $5,000 before they're ripped off, no matter what their remedy is against the assignee, it's limited to the $5,000. So that's how we deal, that's how the FTC dealt with the public policy issue, where we want to make sure that notes and letters of credit can be sold and bought and used in finance around the world, and at the same time protecting borrowers. But we get back to that same problem. How does an attorney representing the non-moneyed entity, the borrower who generally doesn't have tons of cash lying around, in a case where they were defrauded, if there's no chance or there's a significant question as to whether the attorney is going to get paid? And that's where this new rule makes a giant difference. And it says that under the FTC Holder Rule, when a borrower and their attorney succeeds in proving liability against the assignee must pay the borrower's counsel fees. And that one changes so much. It opens the Truth in Lending Act to a viable claim on a number of different cases. Now, I bring those generally anyway, but is not a common claim to bring because the Truth in Lending Act is so opaque and so complicated. But now the FTC has said, and I am certain the courts are going to follow, or certain enough to take these cases, let's put it that way, that the Holder Rule providing for the counsel fees means that attorneys representing borrowers who are ripped off by car dealers and other finance entities are going to be able to get paid when they're able to prove a Truth in Lending Act violation, which happens a lot. And that means that we're going to be able to hold these assignee entities and these bad credit sellers to account. And this is huge news. Now, I did warn you, this is legal wonkiness, so this may not be for everybody, but this is a really, really big deal, and this is how the sausage is made. And this is what I do. I look through the laws, the codes, the jurisprudence to find a relatively unused theory that affects an enormous number of people, which is why I've been concentrating on the Truth in Lending Act for 20 years. And it allows me to affect people's lives to the better in multitude of ways. And it's what makes my business fun. It really is. It's tough, hard, challenging, discouraging sometimes, but overall, it's fun because I get to meet people, talk to people, help people, and screw the bad guys. That's not a bad way to live a life. All right, everybody, be well.